Yeah, so welcome back to the class. Exclusion clause on the side in the first class. It just stopped abruptly, so I had to start another class, and all that. So I will just continue from where I stopped in my last class. Now, so I was talking about DHL International Nigeria Limited versus Mr. Odechukwu Chidi, and then I will continue with where I stopped. I talked about the fact that we are talking about this case where they set down the rule for us, Lestrange v. Grukop or something. And then the rule is that where you have signed documents, right? Signed documents, so far a party has signed a document and there are exclusion clauses contained in that document, that party will be bound by the exclusion clause in the document. And then I told you that this will be the exception. The only time the party will not be bound when he has signed the document is if there was in fact fraud, or there was in fact misrepresentation, or there was in fact duress. That is the only thing, or these are the only things that will stop a party from being bound. So now we're talking about this case of DHL International Nigeria Limited versus Mr. Chidi. And just to give you a recap before I go back to the fact, now we are talking about somebody who wants to deliver something. He wants to deliver something to Federal Polytechnic in Jos, and then he went there. He told the receptionist, I want to deliver something to Jos. It's DHL, so their job is to deliver things across the country. He wanted to deliver the thing to Nasarawa, rather, Federal Polytechnic in Nasarawa. And then they told him that, oh, we don't have an office in Nasarawa, we have our office in Jos. And then he told them that Nasarawa was in Jos. And then that was where I stopped in my last class. Now the respondent then misrepresented to her that Nasarawa was in Jos, whereupon she accepted the package and the 13 naira charge from the respondent. The parcel was sent to Jos and was then returned for non-delivery because Nasarawa was not in Jos. Obviously, if you are a Nigerian, you would know that. As a consequence, the period of application to the Polytechnic Nasarawa expired, and then the respondent therefore lost the prospect of admission for that year. He sued DHL claiming damages for breach of contract as follows: 28 naira for special damages and 9,972 naira as general damages, totaling 10,000 naira. Now, what happened is that when he told the other party, that is the person who is supposed to collect the package and, process it to be sent to Jos, he told the party that Nasarawa was in Jos, right? And then the other party that decided to collect it. But because Nasarawa was not in Jos, they sent it to their office in Jos, but they could not send it to Nasarawa, so to say, because it wasn't in Jos. And she already told him that Nasarawa, that they don't have offices at Nasarawa. So because of that, and they weren't able to send the parcel down there, that's to Nasarawa, the party, that is the guy who went to deliver his admission parcel, he wasn't able to get admission for that year. So because he was not able to get admission for that year, he now sued them and he was claiming 10,000 naira in damages. You might think that 10,000 naira is just very little money as at now, but as at then, in the 90s, 1960s, 1970s, it was a huge sum of money. Now, in the receipts for the parcel issued by the appellant clerk and signed by the respondent, they contained the following clause, exclusion clause. Now, this is what they said. Shipper agrees that DHL, shipper is the guy. So me, if I'm the person who is going to deliver something, I agree that DHL shall not be liable for special, incidental or consequential damages arising from the carriage thereof. DHL disclaims all warranties, express or implied, with respect to this shipment, and the liability of DHL for any loss or damage shall be limited to only 100 naira insurance upon shipper's request and payment thereof. Now, this is what they are saying. They are saying that there is an exclusion clause in the receipt that was signed by the other party. So the other party signed something, and that thing that he signed contained an exclusion clause that they shall not be liable from carriage thereof, that DHL disclaims all warranties, express or implied, with respect to the shipment, and that they will not be liable for special, incidental or consequential damages. Anything that happens as a result of we not being able to deliver your shipment will not be liable whatsoever. And he signed. What is the rule? if you have signed, you will be bound by the exclusion clause. However, the court said something which I feel that we need to look at. Now, the appellant relied on the clause, that's the company, relied on the clause in its defense to the claim. The claim succeeded at the High Court and DHL appealed. That means that the other party succeeded and not DHL. Now, on the question on the effect of the exemption clause, Onolaja, Justice of the Court of Appeal of Nigeria, upheld the finding of the trial judge that the receipt containing the clause was regarded by the parties as a mere receipt. And since the parties regarded the document as a mere receipt, the appellant had failed to establish the document as a contractual document to the respondent at the formation of the contract. Relying on the case of Chapulton versus Barry UDC and Adigun versus AG of Oyo State, Onolaja, Justice of the Court of Appeal, concluded that the reasonable Nigerian would see the document as a mere receipt and as nothing else, and the exemption clause contained in it would not avail the appellant against the respondent's claim. In this respect, the views of Edozie, Justice of the Court of Appeal, on this point and in the same case were different. Applying the rules that laid out by Strange versus Grocob, the learned justice held that since the respondent signed the receipt, he was bound by the exclusion clause. Edozie, Justice of the Court of Appeal, however, went on to hold that the exclusion clause became inoperative because the case was not merely one of laws arising from the carriage of the parcel, which would have covered the exemption clause, but that of non-delivery, which constituted a fundamental breach of contract against which an exclusion clause was of no avail. Now, let us now look at what we are talking about. This is a very interesting case. The reason why it's interesting is because we have Onolaja saying one thing, Onolaja, Justice of the Court of Appeal, saying one thing, and we have Edozie, Justice of the Court of Appeal, saying another. They do not agree on whatever they are holding. Now, let us start from the point of view of the Justice Onolaja of the Court of Appeal. What is he saying? He's telling us that this is what Justice Onolaja is doing. He's totally ignoring the rule of signed documents. Why is he ignoring the rule of signed documents? We can't tell, but how is he doing so? He's doing so by saying that it is a mere receipt. By the time you are bringing that word, mere receipt, you are looking at things from the angle of unsigned documents. He is saying that it is a mere receipt, and since it's a mere receipt, anything contained in that mere receipt, if it was not brought to the attention of the party, would not be binding on the party. You know that I gave you a breakdown here where there are writings in a particular thing. In this case is a receipt, and those writings contain condition. We then have to look at whether or not it's a contractual document. If it's a contractual document, you read them or you know read them or you know consign us, it will be binding on you. But if it's not a contractual document, then you must have taken reasonable step to bring it to the attention of the party. What Onolaja, Justice of the Court of Appeal, is saying is whether or not he signed the receipt is immaterial. This is what he's saying. The signature on the receipt is immaterial. What is material is whether or not the receipt is a contractual document. That the rule here would only apply to contractual documents and not to documents that are determined to be non-contractual. For example, a mere receipt. And so, because a reasonable person would not have looked for conditions in a mere receipt, regardless of the fact that the receipt was signed, it would not be binding on, the party. Do you understand? However, Edozie GSC said, no, I don't agree with you, Justice Onolaja. So Edozie GSC now says that applying the rules laid down in this case, it says that the learned justice held that since the respondent signed the receipt, he was bound by what is on it. Do you understand? So you can see that they are looking at things from two different perspectives. One is telling us that since the party, Edozie JSC, since the party signed the receipt, he is bound by the exclusion clause on the receipt. The other party is saying, even though he signed the receipt, he is not bound by the exclusion clause on the receipt because the receipt cannot be termed a contractual document well enough for him to be said to have knowledge of the content of the receipt. If it was a contractual document and then he signed it, then he will be deemed to have a knowledge. But if it is not a contractual document and he signs it, are you listening to me? If it's not a contractual document and he signs it, he would not be bound. That's Onolaja. Edozie saying contractual document or not is inconsequential. What's consequential? Did he sign it? The moment you sign it, this will be used against you, which says that for every document that is signed, you'll be bound by it. Do you understand that? However, Edozie JSC still said that he would not be bound, although because he signed it, he will be bound by the exclusion clause, but that exclusion clause is not binding in this context. Why? He said he went further to hold that the exclusion clause became operative. Why? Because the case was not merely one of loss arising from the carriage of the parcel. Are you listening to me? The case here, we are not talking about one that arose. That's a case that arose from the carriage of the parcel while they were carrying it. This one, they did not even try to deliver it. This one is on non-delivery. What their exclusion clause exempted them for was in the event where they carried it from one place to the other, if they were not able to deliver it, or if while delivering it wasn't in the perfect condition that it was given, or there is any comma, so to say, but it must have left their office on the way to, or when it gets there, maybe it gets there late or not. Do you understand? Anything that happens, Edozie was trying to tell us that in this case we are not looking at it from that angle, because that is the angle that there was an exclusion clause to evade liability. This is it. Edozie went further to hold that the exclusion clause became inoperative because the case was not merely one of loss arising from the carriage of the parcel, which would have been covered by the exemption clause. Now that's why. So what this is it here, we have a contract, right? There is an exemption clause in the contract, but the exemption clause was basically on carriage of parcel, any consequence as a result of the carriage of the parcel. But this guy is telling us that this one is on non-delivery of the parcel and therefore does not come under the exception clause, because the exception clause only exempt liabilities from the carriage of the parcel. Do you understand? That means that it must have left their offices to go anywhere that it intended to go. Probably did not get there on time, or it got there to when it got there it was damaged. Anything that could have arisen rather, you know, or yes, that could have arisen from the carriage of the parcel, then that's what the exemption clause covers. But in this case, it did not cover the non-delivery of the parcel. Do you understand that? So according to Edozie, he is saying that the reason the exemption clause would not be applicable, they arrived at the same conclusion. This is the conclusion: exemption clause not applicable. That's the judgment of the court, right? Onolaja JCA and Edozie JCA, they arrived at this place that the exemption clause was not applicable. But Onolaja followed this route. This one followed this route. Onolaja said that it wasn't applicable. Why? Because it was a mere receipt, right? Because it's a mere receipt, it's not applicable. Why? Do you understand? It's not a contractual document. But Edozie, before he said that it is supposed to be binding because it's a signed document, but the particular cause of action is not based on carriage of goods, which the exclusion clause covers, but based on non-delivery. So at the end of the day, they arrived at the fact that the exclusion clause was not applicable, but they just got there using different rationale. Do you understand that? Is there anything wrong? Yes, they just got there using different rationale. Now, we go to our next case of Chagri versus Adebayo. Chagri versus Adebayo, the party signing is equally liable if he signs a document incorporating by reference another document containing the exemption clause. Do not forget that in my last class, when I was talking to you on this particular issue, I told you when you are talking about incorporating documents, I told you that in this particular document, if it's not a signed document and there's a document here that the other party can see, you know, and know that, okay, there is an exemption clause. If you are referring to another document, you must incorporate that document into it. You must incorporate it by reference to that document. That is the case of Cabo Air versus Tafa, right? Cabo Air and Tafa, they did not incorporate, and due to that, the court said that, you know, that document does not form part of this contract. So in this case, how does the court look at it from the point of view of documents that are containing exemption clauses but are not part of the signed document? In the case of Chagri versus Adebayo, the plaintiff respondent claimed that he won £500 The plaintiff respondent claimed that he won £500 as a result of the £1 he staked with the defendant appellant, that is a football pools company. The company refused to pay him his win, and when when sued, relied on the rules and conditions of the ambassador fixed odd pools, which entitled the defendant to cancel any entry and refuse payment. The plaintiff had signed a document containing these words: "I have read and agreed to the rules and conditions." The rules and conditions were in fact not in the signed document but in a separate document. The question was whether the defendant has done all that was reasonably sufficient to bring the clause to the plaintiff's notice. So this is it, right? So, when they want to, the way we used to do sports bet and all that, very good. So now he wanted to do sports bets, play lottery. But for each time that you're about to do it, there is this document that you must sign. Do you understand? So he staked £1 and then signed the document. Now that document said, I have read and agree to the rules and condition. That was what the document said. Now the rules and condition was not in the document. The rules and condition is in another document. Do you understand that? The rules and condition was in another document and not this document when he signed it. Now when he then, and this the part of the rules and condition says that even if a person wins, they can cancel payment at any point, refuse payment and all those kind of things. So he's now suing them because he won £500. He staked £1, he won £500. So he's now suing them to collect £500, and then they refuse payment, and then they are relying on that part of the rules. Okay, let me show you what I'm talking about. So this is what the plaintiff signed here, and then this is where they put the rules and condition. Right now, in this thing that the plaintiff signed, it was written, I have read the rules and condition when he signed it here. So this is his signature. I have read the rules and condition. But the rules and condition is not here. The rules and condition is in another book. Do you get? And then what the other party is relying on is on this rules and condition, because there is an exclusion clause in the rules and condition. And then the court now is to determine whether or not the party has brought this rules and condition to the notice of this person who signed it. Because if they did not bring it to the notice, obviously it will not be binding on the person. So have they done all that is reasonably necessary to bring this notice and condition to the attention of this party? So let's look at it. The court of first instance, a magistrate court applying the rule. The court of first instance, a magistrate court applying the rules laid down by Parker versus Southeastern Railway for unsigned documents, held that the defendant had not done what was reasonably sufficient. On appeal to the Lagos High Court, Taylor CJ, this decision was reversed. Now, I don't understand. It's a signed document. Why is the magistrate court applying the case of Parker versus Southeastern Railway? That is not the case to apply. Do you understand that you are not supposed to apply Parker versus Southeastern Railway when we are talking about signed documents? We only apply that case when we are talking about unsigned documents, and in this case it's totally different. So on that issue alone, I would disagree with the magistrate court. So, and that's the same thing that Taylor CJ, in this particular case, when they appealed the case to the Lagos State High Court, Taylor CJ reversed the decision. Now, the principle applicable to signed documents were, according to the court, totally different from those applicable to unsigned documents. I love what Taylor CJ is saying. Where the accepting party has signed a document which form part of the contract and contains or refers to conditions, he will be bound by those conditions whether he reads it or not, unless he has been induced to sign the document by fraud or misrepresentation. Whereas in this case, some of the terms and conditions are contained in other documents apart from the one signed, the court has this to say. It seems to me that it makes little difference that the agreement is to be spelled out in two or more documents, provided the plaintiff is, in this case, has signed the principal document and certified that he has done here that the other document containing the agreement has been brought to his notice. Now, don't forget that what he said here, what was written there, which he did not write it, they wrote it and then he signed. I have read the rules and conditions. He assented. I have read the rules and conditions, and then he assented. That is reasonable notice. Imagine you want to sign something and then they said, okay, let me, you are about to sign something, and then what was written there is, I have read the death notes. What will come to your head? Waiting the death notes. What is that? Do you understand? You begin to question, do you understand? Someone tells you, I've read the death, DEATH notes. you that you are about to sign and read the death note, would your head ring that what is that? Do you understand what I'm saying? Or access to access to my account, you know, all those kind of things, and then you now sign it. Do you understand what I'm saying? So when he said I have read the rules and condition, it is taken for granted that the rules and condition has been brought to your notice, because what a reasonable person is supposed to do when he says I have read the rules and condition, where the rules and conditions they, that's the first thing that's going to come to my head, because I'll then begin to look at the document again. That I can't find rules and condition in this document. Where is it? So if he decided not to read the rules and condition and has said that he has read the rules and condition, the court will take it for granted that he has read the rules and condition, and he cannot later say that the rules and condition was not brought to his attention when he himself assented to the fact that he has read the rules and condition. Do you understand that? Now, I noted something. In this case, the plaintiff was bound by the rules and condition not because he had read them, but because he signed the main pool's agreement certifying that in fact he has read them. So that's what I'm saying. We don't care in law in relation to this rule. We don't care whether or not you had read the covenant or the exclusion clause. Did you assent in relation to signed documents? Did you assent to reading them? If you do, then you must be bound by the content of it. Now, the next case, which seems to be in contrast with, this particular case here, the next case is the case of Chike Atu. Let me look at it well. Chike Atu versus face-to-face $1 million fixed odd pose. Chike Atu versus face-to-face $1 million fixed odd pose limited. Oputa J, as it then was sitting in Onitsha High Court a year later, arrived at an opposite decision on rather similar facts. Now, he said the fact of the case is that there appear to be one vital difference. They have the same facts. Basically, the both cases have the same facts, but this one has one vital difference. Now, the document signed in this case merely contains the word "read the rules." Do you understand? He did not say that I have read the rules. No, the document. This is the document that he signed. You know, this one says I have read the rules. This one just said read the rules. Now, in this document there were rules. In another document there were rules, and then it was the rule that is in this other document that had the exclusion clause that they were relying on. Do you understand? Now, the document said read the rules, and then in this document there were rules, and in the rules in this document there was no exclusion clause. But there is another rule which you would not know, because they did not say read the rule in this document and another document. They just said read the rules, and then this document there were rules and he signed, and then there is another document where there were rules and it contained exclusion clause which they wanted to rely on, which he did not sign. Now, the defendant signed in this case merely the document signed in this case merely contained the word read the rules. The defendant pool's company argued that the rules referred to were those contained in the coupon signed, and others, the vital one in this case, contained in another document, that is the defendant company rules, stating that the onus was on the defendant to prove that they had done everything necessary and reasonably sufficient to bring the rules and conditions to the attention of the plaintiff. The court added that this had not been done. The plaintiff could therefore not be bound on the coupon exhibit 3 and not specifically referable to any particular rules, especially as the coupon itself contains some rules. There is nothing in the coupon exhibit 3 or from the fact and the circumstances of this case to suggest that the rules referred to in exhibit 3 were the rules and conditions for 1971-1972 season exhibit 2. In this case, I am satisfied that there was on the coupon exhibit 3 no reference whatsoever to the one in this one. Now, this is what the court was saying. You said read the rules or read our rules, right? No problem. Now, in this document that he was signing, there were rules, right? And there was nothing specifically to let him understand that the rules that we are referring to is not only the one here. There are other rules in this. He didn't even know of the existence of this document that had this rule. He did not know of the existence. If you had said read the rules in this document and in our company rules, do you get? They would have brought it to his attention, but they just said read the rules. Okay, If another argument is that if that document did not have rules, then it would have given you what? Red light. That okay, oh, this document I'm about to sign does not have rules, right? And it says read the rules. Okay, where are the rules? If the rules are not here, where are they? Right? But he says read the rules, and in this document I can see rules, and he does not specifically lead me to any other document that there are rules. I did not know. There's no way I can know on the face of this document that he was referring to another document that there are rules. What do you expect me to do? Do you get? And that's what the court is saying, that if he's going to rely on the exclusion clause in this one has not been expressly referred to in a reasonable manner, in such a way that a reasonable person would, say, okay, where are the rules here? So in the event that that is not done, even if he signed here, he cannot be bound by the exclusion clause here. Simple. Do you understand that? Now, clearly, therefore, this case is distinguishable from our case of Chagri versus Adebayo. For in the latter, not only did the plaintiff sign the principal agreement, he further certified that he had read and agreed to the rules and conditions. It was therefore relevant that the rules and conditions referred to were contained in another document. In Chike Atu's case, however, he signed a document warning him to read our rules. Since the document signed contained rules, in the absence of contrary evidence, he could not be bound. He could only be bound by the rules contained in the signed document and not in any other. The court in this case rejected the defendant's argument for failing to satisfy the test applicable to unsigned documents. Another way of looking at the matter is to regard the defendant's conduct as constituting a misrepresentation, and therefore an exception to the rule that the party who signs a document is bound by the terms in it. The misrepresentation here is that the defendant induced the plaintiff to sign a document under the impression that the complete contract was contained in that document, whereas unknown to the plaintiff but known to the defendant, other vital terms of the contract were contained in another document. Now, this is the misrepresentation argument. Now, in this case, how is it misrepresentation? He said, read our rules. Now, it is such a misrepresentation. Why? Because there are certain details in relation to the company who said read our rules that are not made known to the other party when he signed the contract. So when he said read our rules, the only rules that were made available to be read were those ones in this contract. And then now, when there is a problem, you now want to go and bring other rules. But as at the time when you were signing the contract and you said read our rules, if you had said, let us say this one is called the coupon rule and then this one is called the company policy rule, if it had said read our coupon rule and read our company policy rule, he would have looked at it, coupon rule, okay, this one is here, where is the company policy rule? Okay. But or if he had said read our rule and read our company policy rule, because of the word and, a reasonable person will be saying, okay, so which one is the rule, oh? Which one is the company policy rule, oh? Sure, you get. But in this case, all you said was read our rule, and the only rule that you made known to him was this one. You did not make known to him this rule. What did you expect him to do? Do you understand? So therefore, that is a misrepresentation, because the company knew that there were more than one rules, while the company only made available one particular rule, misrepresenting to him that there are existence of other rules, and now wanting to rely. So you can look at it from the point of view. I told you that when they assign documents, it would not be binding if you have a fraud, misrepresentation, or duress. In this case, there is the absence of misrepresentation, but because he has misrepresented to him the rules that he was referring to, or the rules that exist, he is just telling him that there is only one rule that exists, per the fact that he gave him this to sign and did not bring to his notice this. So therefore there's misrepresentation, and therefore he cannot be bound by it. And so we go to our last case of Curtis versus Chemical Cleaning and Dyeing Company. Curtis versus Chemical Cleaning and Dyeing Company, our last case for this class before my last class. In this case, the plaintiff took a white satin wedding dress to the defendant's shop for cleaning. She was asked to sign a receipt which contained a clause exempting the defendant from all liability for damage of articles claimed. The plaintiff asked the defendant why her signature was required, and she was told that the defendant would not accept liability for certain specified risk, in this case for any damage done to the beads and sequins. When the dress was returned badly stained, the plaintiff sued for negligence, and defendant was not allowed to rely on the exclusion clause by the plaintiff because she has induced the plaintiff to believe that the clause only referred to beads and sequins. That is misrepresentation. So now I want you to look at what happened here. In this case of Curtis versus Chemical Cleaning and Dyeing Company, what happened here? We are talking about somebody who went to give her cloth to dry cleaner. Her cloth is a satin wedding dress. She went to give it to a dry cleaner, and then she was given a receipt which she was told to sign. And then she asked, why am I signing this? And then the other party, now you should know that that receipt has a exclusion clause that is broad enough. Are you listening to me? Now, and then she asked, why am I signing this, right? The plaintiff asked the defendant why her signature was required, and she was told that that the defendant would not accept liability for certain risk, right? In this case, for damage done to the beads and sequin. So the person at the counter, the receptionist, who told her, oh yeah, sign. She now asked, why are they signing? Why am I signing? And then the person at the counter then told her that, oh, you are signing because the company would not specify, though, the company would not be liable for any damage done to your bead and to your sequin. You know that on wedding dress there are so many flowery designs and beads and all that. So she was trying to tell her that if there are any damages to your beads and your sequin, the company will not be liable. That was what the person at the counter said. Do not forget that there is an exclusion clause in the receipt, but that exclusion clause is broad enough. Do you understand? If you follow what a dossier said in this case, that even, you know, the problem as to whether or not receipts, if signed, would amount to contractual document well enough to be binding. This is a battle here, but in this English case, it was a well enough document to be binding, right? Good. But the question is, would that exclusion clause, the broad one, would they absolve the company of liability? Or would that statement that girl made to the woman when she asked, why do you need my signature? When she said that the company would not be would not be liable for any damage to your bead and sequin, is now a misrepresentation, because she signed based on the statement that was made that where there is a damage to your bead and sequin, limiting the liability to only bead and sequin, it was because it was limited to those things that, you know, the other party then signed. Do you understand that? So she signed based on the misrepresentation of fact given by the other party, which is that we are not going to be liable for bead and sequin. So when the cloth came back, the bead and sequins were intact, but the cloth was badly stained. And then they now want to rely on the general one, on the receipt that she signed. That is the general, this thing that absolved the company of every liability. And then she said, no. Yes, there is a general one. But when I asked this woman, that is the woman at the counter, she told me that it is only for bead and sequin. That is, if there is any damage to bead and sequin. And in this case, the damage here is not to bead and sequin. The damage here is to my clothes being stained. So you cannot rely on the general one. And then when the dress was returned badly stained, the plaintiff sued for negligence, and defendants were not allowed to rely on the clause signed by the plaintiff because she had been induced to believe that the clause only referred to the beads and sequins. Now, according to Lord Denning, any behavior by words or conduct is sufficient to be a misrepresentation if it is such as to mislead the other party as to the existence of the extent of exemption. If it conveys a false impression, that is enough. I want us to listen to what Lord Denning said again. Any behavior, words or conduct, any behavior, words or conduct is sufficient to amount to what? Misrepresentation. If it is to mislead the other party as to the existence or extent of exemption. Anything you say or anyhow you act will be misrepresentation if it misleads the other party to think that it is going to be the extent of the exemption. If it conveys a false impression, that is enough. So in this case, what the girl at the counter, she made express statement which made the other party here believe that the damage is only to the extent of the bid and sequin being damaged. That's where the extent of which the exclusion clause is going to operate. So if she has misrepresented the fact to the person there, then at the end of the day, the company cannot rely on the general exclusion clause in the receipt. That is what we learned in this case, and that's where I'll be ending our class for this particular topic on rules guiding exclusion clause under signed documents. So to just wrap up, we already know the rules. What is the rule? Once it's signed, then it's what? It's binding. That's the general rule. However, when it is signed and there is fraud, there is misrepresentation, or there is duress, then it would not be binding, right? There is this debate as to whether or not receipt is a contractual document which, when signed, would also be binding if it contains exclusion clause. Onolaja JCA does not agree. Onolaja JCA thinks that the receipt will always be a mere receipt, signed or not, while Edozie JCA is saying that so far it's signed, it is applicable and all that. And then we looked at other cases. In my next and final class on this topic of exclusion clause, we'll be talking about the general rule governing the restriction of exclusion clauses. There are 3 rules governing the restriction of exclusion clauses, but under 2 subheading. What are the 2 subheading? The contra proferatem rule and third party rule. Under the contra proferatem rule, then we are looking at the strict interpretation and negligence. Strict interpretation and negligence. And under the third party rule, we are looking at whether a third party who is not privy to the contract can benefit from the exclusion clause of the contract. And after these 3 things, which we'll discuss in our last class, we'll end our class for exclusion clause in its entirety. I hope you enjoyed this class to the end. I'm so sorry that there is very little illumination. That's due to the fact that there's no light. And welcome to Nigeria, and the weather is not so bright, so that's the reason we have very little illumination. So regardless of the fact that forces are working against us, we must have the class regardless, and I hope that you've learned a lot. So thank you very much. I will see you in my next class.